Welcome to this explainer. Let's just dive straight in, shall we? Today, we are exploring a highly structured playbook for navigating the really complex and, let's be honest, often totally overwhelming child support system. We've pulled together some fascinating insights from family law attorneys and legal advocates to walk through their comprehensive guide. We're specifically focusing on ways fathers can protect themselves, build a winning strategy, and understand the hidden mechanics of family court. We're going to cover 6 crucial ways to protect your rights, what absolutely not to say in court, and how to avoid being trapped in a system that, well, many advocates argue is frequently stacked against fathers. Let's get to it.
Men only get flowers when they pass away once in their life. Man, that is heavy, right? We're starting with this incredibly poignant quote because it brilliantly illustrates the emotional weight that fatherhood carries. It really sets the stage for why understanding the system is so vital. It's not just about the money, it's about protecting your fundamental right to be a parent. When fathers walk into family court, the stakes literally couldn't be higher. So how do you protect that bond? Well, to answer that, we first have to understand the actual machine you're walking into.
And to understand that machine, just take a look at this massive number, $735 million. According to our sources, this is the amount of incentive money states are receiving for the 2025 fiscal year. But what exactly is all this cash for? It's specifically for establishing paternity and collecting child support. Advocates point out that this immense financial incentive fundamentally changes the whole dynamic of the courtroom. It creates a system that is highly motivated to find people liable. Which brings us right to Title 4D. This is the federal program providing those massive financial incentives to state agencies. Legal advocates argue this creates what they describe as a leeching system, basically transforming child support from a family-focused service into a revenue-generating business for the state. They highlight a major potential conflict of interest here. If the state gets a cut or a bonus based on how much child support it establishes and collects, can a father truly get an impartial, fair hearing in a state-run administrative court? Proponents of the movement challenging these systems frequently point to the Supreme Court case Blessing versus Freestone. They use this case to argue a pretty shocking concept. The system is actually built to recoup government assistance funds, things like welfare or food stamps, back to the state, not necessarily just to aid the children. Our sources emphasize that understanding this shift in perspective is absolutely step 1 in preparing your defense. All right, Section 1, Administrative versus Judicial Courts. Let's explore the hidden mechanics of how these state cases are actually processed. Because not all courts are created equal. State Department of Revenue child support cases often happen in fast-tracked administrative hearings. These are basically quasi-courts built for speed. They completely lack the strict due process of a real circuit court. In a circuit court, you have a real judge, strict rules of evidence, and guaranteed constitutional rights. But in an administrative court, the state is pushing cases through rapidly, which advocates warn can easily stomp all over your rights if you aren't paying close attention. Which leads us to the most dangerous trap of the administrative system. Silence equals consent. If you get a letter from the child support agency and you just toss it in a drawer and ignore it, the administrative court legally presumes that you agree to their terms. They will simply issue a default judgment against you. You could be deemed the legal father in order to pay maximum support, all because you didn't mail back a response. You absolutely cannot stick your head in the sand here. So how do we fight back? Strategy number 1, custody is your shield. This is your ultimate defense. Getting joint physical custody is paramount. Why? Because without it, the state automatically presumes you have abandoned your rights, leaving you completely vulnerable as the non-custodial parent. When you secure joint physical custody, it forces the court to make a much fairer financial calculation based on your actual placement time. And honestly, more importantly, it asserts your fundamental constitutional right to parent your child, ensuring you remain a constant presence in their life. This brings up a really fascinating question for strategy number 2. You might naturally think that demanding the other parent's financial records is a foolproof legal strategy, right? After all, shouldn't both incomes matter? Well, let's see what family law actually dictates. As family law attorneys are quick to point out, in states like Wisconsin, courts often completely ignore the custodial parent's income if you don't already have shared or equal physical placement. So filing motions to compel financial documents will completely fail if the court deems that income irrelevant to their specific formula. This emphasizes exactly why knowing your specific state laws and fighting for shared placement first is incredibly critical to your success. Moving right along, strategy number 3, paperwork and procedure. Knowing how to handle the paperwork is your best defense against default judgments. Listen, if you are served with State Department of Revenue papers, you have to act immediately. You usually have a very short window, often just 20 days, to formally object to the administrative process. In writing, you must demand a circuit court hearing to ensure you actually get your due process. At the exact same time, file an official petition for joint physical custody in that circuit court. This moves the whole battlegrounds to a place where evidence and your rights actually matter. Okay, for strategy number 4, we have to look at a massive trap, the Bradley Amendment. This federal law dictates that overdue child support becomes a permanent judgment the exact day it is missed. This means courts generally cannot go back in time to erase or forgive that debt, no matter how good your excuse is. It doesn't matter if you lost your job or were in the hospital. Once it's owed for good. Because of that law, if your child actually moves in with you, you cannot, I repeat, cannot simply stop paying child support to the state. You literally have to file a motion to modify support the very day they move in. Judges can only alter the order from the date you file your paperwork forward. And you have to bring hard proof to the court: school records showing your address, medical bills, tax. If you can't prove it with paperwork, the judge simply cannot credit you. Strategy number 5 is for those who feel the system just totally bypassed them. You have the right to inspect your original court file. Advocates highly recommend using FOIL or FOII requests at the county clerk's office. You are looking for what they call extrinsic fraud. Did a real judge actually sign your paperwork, or was it just a temporary administrative officer? Were you actually served properly, or is the proof of service blank or even forged? Finding these procedural errors can be the master key to unraveling a really bad judgment.
Which brings us to strategy number 6, winning in the courtroom. This is all about your actual courtroom presentation.
Believe it or not, judges size you up the literal second you walk through those doors. The parent who shows up in a suit, carrying organized physical folders of documentation and speaks pure, calm facts, they will almost always have a massive advantage. On the flip side, the parent who shows up unprepared, angry, and tries to treat the courtroom like a therapy session is going to lose credibility instantly. When it comes to what not to say in court, please remember this rule. Never, ever argue from emotion. Don't vent about how unfair your ex is being. The judge doesn't care about your feelings, as harsh as that sounds. They care about the law and the proof. Only argue from documented evidence. Your presentation and your facts are literally your only weapons in that room. Now, with all these strategies we've discussed, you might be wondering, is there a silver bullet? Can you just use a simple legal hack to get the entire case thrown out? The short answer? No way. As family law experts point out, despite what you might see promised by gurus online, outright dismissals are an extreme remedy. They are rarely granted unless you have absolute proof of egregious misconduct or severe procedural fraud, like a clearly forged signature. This is exactly why sticking to realistic, evidence-based defenses, like fighting for shared placement and correcting income calculations, is so vital. Because navigating all of this can be, quite frankly, incredibly daunting, advocates highly recommend utilizing specialized resources. Our sources point to tools like DadAide, which is designed specifically to help fathers learn the system inside and out, prepare their cases efficiently, file motions easily, and ultimately save time and money while greatly improving their chances of winning. The core message here is to empower your legal strategy rather than trying to go it alone. And this brings us to the crucial point from all of our sources today. Knowing the law simply isn't enough. You can read every case file and watch every explainer, but information is totally useless if it is not applied. You must proactively use this knowledge, file the paperwork, demand your rights, and advocate fiercely for yourself and your kids. I'm going to leave you with this final thought to ponder. We learned today that in this administrative system, your silence is legally treated as your consent. You simply cannot afford to be passive. So knowing that, how will you use the strategies from this explainer to take action, protect your family, and secure your parental rights today? Thank you so much for joining me to unpack this essential playbook. Catch you next time.